So you've applied for an administrative land use permit and the city denied it. Or maybe you're a neighbor who disagrees with the administrative land use decision the city just made. Can you go straight to court? The answer is no. Utah law requires you to follow what's called an administrative appeal process first. Think of it as a required pathway. Before you can take a land use dispute to court, you must first give the local government a chance to review its own decision. So what exactly is an administrative appeal? It's a formal process where you ask the local government to review an administrative land use decision made by the agency's designated land use authority for your application type. Every city and county in Utah must provide this appeal process in their local ordinances. The details vary by municipality, but the basic framework is the same. Here's how it typically works. First, after a formal administrative decision is made, you file a written appeal within a deadline specified in the local ordinance, usually a specific number of days after the decision you're appealing. This isn't optional. If you miss your deadline, you lose your right to appeal. Second, your appeal must be based on substantial evidence on the record. The record refers to all the evidence and testimony presented during the original proceedings, planning commission meetings, staff reports, public hearings, everything officially documented. Substantial evidence means you need real facts and documentation from that record, not just opinions or general objections. The primary focus of an administrative appeal will be on whether the land use authority correctly applied and interpreted relevant ordinances and if procedures listed in the ordinances were properly followed. One thing worth noting is that the person who has the burden of proof in an appeal is the person who's doing the appealing. If you're the original applicant challenging a denial, the burden is on you to show the decision was wrong. If you're a neighbor or other affected party challenging the approval, the burden is also on you, but you'll need to show the decision was either illegal or that the facts the decision was based on were clearly wrong. Third, understand who hears your appeal. In most municipalities, if you're appealing a planning commission decision, the appeal has traditionally gone to the city or county council. However, effective July of 2026, cities of the first class through the fourth class and even some fifth class cities may no longer designate their legislative body, which is the city council, as an appeal authority. These municipalities must establish a separate body to hear appeals. If you're appealing a decision by an appointed board of adjustment or other designated land use authority, the appeal process might differ. So again, check your local ordinances and the most current state legislation. The appeal authority will review the record, consider your arguments, and make a decision. They might uphold the original decision, reverse it, or send it back for further consideration. This is your opportunity for the local government to self-correct if an error was made. Only after you've completed this administrative appeal process can you take the matter to court. Utah law is strict about this requirement. If you skip the administrative appeal and file a court action without first exhausting the required administrative remedies, the court will not entertain your judicial challenge and will typically dismiss or refuse review because you must first exhaust your local remedies. Why does Utah have this requirement? Two important reasons. First, administrative appeals are designed to be faster and less expensive than court proceedings. They give everyone a chance to resolve disputes without the cost and delay of litigation. Second, they give local governments an opportunity to review and potentially correct their own decisions before courts get involved. It's all about efficiency and accountability. So here's what you need to remember as a property owner or a concerned citizen. Read your local municipal code carefully. Know the appeal deadlines. They're usually short. Base your appeal on substantial evidence from the record, not general complaints. Follow the process exactly as it's written. And if you're still unsatisfied after an administrative appeal, then you can go to court. For cities and counties, maintaining a clear, well-documented administrative appeal process protects you. It provides foundational strength to your processes by helping to improve actions and giving you a chance to catch and correct errors before they become expensive lawsuits. Make sure your ordinances clearly spell out deadlines, procedures, and who hears appeals, and keep thorough records of all proceedings. That record is what appeals are built on. If you have questions about land use law or feel you've been treated unfairly in a land use application process, you can contact the Office of Property Rights Ombudsman with questions about land use law. This educational content was developed for the Land Use Academy of Utah. Funding was provided through the Land Use Training Fund, which is administered by the Office of the Property Rights Ombudsman, utilizing a portion of the 1% surcharge on all building permits in the state of Utah. The role of this organization in administering funding is primarily administrative and should not be viewed as legal advice. Always consult your legal representative when addressing land use activities.